Please, Manoj. Manoj, may I first express my deepest gratitude for the immense patience that you've shown to all of us on the petitioner side. You've not cut us short terribly, and you've allowed us all wide leeway and latitude. So I'm grateful for that. Manoj, I appear in writ petition 1068 of 2019 on behalf of Soeb Qureshi. Soeb Qureshi is an advocate on record of this court as well. He's from Kashmir. There are a large batch of petitions before my lords, which includes people who are not only from Kashmir, who are not only politicians. It includes a former Home Secretary from Kerala. It includes professors, educationists, etc. The reason why I mention this is this case, the way we see it, is not a case only for Kashmir or Kashmiris. It actually opens a vista to many multifarious abuses that the executive can heap on the constitution if the means that they have adopted were to be utilized in future as well. There is a principle called obsta principis, which means that whenever anything that is approaching or encroaching upon our rights starts, you must nip it in the bud. That's the reason we are all here. Because this is an encroachment on something we cherish the most, which is our constitution. Kashmir is just an example or an avenue for how that is done. And I will seek to demonstrate how that is. Now, your lordships were right when you said I've been here for 12 days, but your lordships have also been here for 12 days. So I've seen all the arguments that's come before mine, which is why I've managed to cut and crop a lot which has already been covered. I will largely be adopting the arguments that have been made by Mr. Chandrachud Singh and Dr. Dhawan and Ms. Nitya Ramakrishnan. Because I'm appearing for an advocate, I feel it was my duty, and this is what the instructions I have from aforementioned advocate, to ensure that, well, we must be careful when we assist a constitution bench to ensure that the court avoids pitfalls. Now, it would not be fair of us to present a case which is not supported by the precedent or which the precedent has specifically squashed, which has happened, and I'm afraid I'll have to do that fairly unpleasant task of differing from some of the counsels who came before me on a couple of points. I want to clear that up right now. The first, Mr. Dwivedi, he made arguments, Manoj, with reference to 370 clause 3 not surviving, and the entirety of 370 therefore not survive, that the entirety of it had come to an end. Your lordships had said constitutional practice would trump that. There was subsequent constitutional practice. But I'm afraid this was the exact argument that was taken before this bench, and where your lordships passed the order in the Shah Faisal matter when the reference was sought. Now, the reason is Sampath Prakash, which is the 5 judges bench, had that argument taken before it, saying that 370 has come to an end. So you couldn't pass any orders after 1957 by advertence to 370 clause 1. Sampath Prakash squarely rejected it. And when, in fact, a couple of our colleagues had wanted to have that reference, we also argued, as did the government, that it should not be referred. There's no conflict. This position is fine by us. So in fairness, I must tell your lordships that the Shah Faisal judgment is in volume 17. It's PDF 42.
Could you repeat that again, please?
Volume 17. Case law volume 17.
Yes.
PDF 42. The extract of Sampath Prakash is at para 40. And Sampath Prakash's reasoning is that CO 44, which was the 1952 CO, if your lordship will remember, that was the one issued under Article 370, Clause 3, the 1952 one. Thereafter, in 1954, with the Constituent Assembly, they issued 371D, the 1954 order. Now, the 1952 order is proof of the fact that the order itself says that we allow 370 to continue to stand except for this modification and that explanation. Your Lordship will remember yesterday that explanation much was being made of it. So it was the conscious choice made at that point in 1952 by the Constituent Assembly, because that's the threshold. That's when we are going to go ahead and make the Constitution. Now, if we are going to activate 370 clause 3, why embark on this exercise? We get the entire Constitution to apply. But because they made that conscious choice in 1952, they issued that, the one and only order that's ever been issued under 370 clause 3 until 2019, which is the 1952 order. Now that 1952 order is the reasoning adopted by the Sampak Prakash bench to say, since you yourself have taken the decision that the Constitution of India will apply with exceptions and modifications, and the only exception or modification you have brought in is that explanation, which was a question that fell in Damnu later. But because you yourself have said that, it's an accepted fact that 370 continues to apply. That is your conscious choice. I'm corrected to say it's a declaration, Malons, not an order. It's a declaration under 370 clause 3. And at para 44 of Shah Faisal, para 40 is where this extract of Sampat Prakash is. CO 44 is referred. And at para 44, your Lordships have given that as the reason why you're not referring this to a larger bench. The third reason given in para 44. The second, again, I'm afraid of, I'm sorry for the broadside, but I have to be accurate on this. Article 357, there was an argument taken by Mr. Parekh yesterday. And he was saying the part of it doesn't apply. In fact, it does, which, if your Lordships recall, how they issued these orders under 371D was they chose the part and said the part will apply subject to A, B, C exceptions or modifications. So they would refer to the article under it and then make those corrections. If you compare page 18 of volume 3, which is the first order, when 357 was not made applicable, with page 38 PDF of volume 3, so that's 1952, I think, and 54 first, and then 1958. Now, page 38 is 58. They, while bringing 357 back, 360 is omitted. So 357 continues to apply fully. So it wouldn't be appropriate for us to argue that 357 doesn't apply in the state of Jammu and Kashmir. In any event, when you see volume 1, page 188, which is the documents dealing with how the Constitution of India applies to Jammu and Kashmir, that page you'll find 357 there as it